Trump won his hearing with the Supreme Court and was placed back on the Colorado ballot. What the hell happened? Hello, all you beautiful people. World's okayest lawyer here, busting out some yeehaw for the Houston rodeo. I have seen folks arguing about flooding the courts. The Supreme Court is filled with Republicans. The liberal justices are sellouts. But do you actually know what the case was and additionally what was said? Case number 23716, Trump v. Anderson, was ruled on March 4th, 2024, just 2 days before this filming. It was a per curiam ruling, meaning that it was the opinion of the court as a whole instead of a single justice signing the bottom of the document. If you really think about it, this makes so much sense with all the vitriol from one side and all the rock star status from the other. And then there is this rest of us in the middle. What justice really wanted to throw their name on this opinion? So what did the court say? In the 20-page opinion, and I'm including the additions that were added by the other justices, the Supreme Court first discussed the basis of the case being before their court, specifically highlighting January 6, 2021 and the 14th Amendment, which states no person can serve in Congress as a judge or justice or the presidency if they previously swore an oath to the Constitution. Think back when Trump was sworn into office. Then engage in insurrection or provide comfort or aid to the insurrectionists. Shameless plug, I posted a video back in January of 2024 regarding the laws of insurrection dating back prior to the Constitution of the United States. Please give that a listen. I have put that link to that post in the comment section of this post. They further discuss how the case arrived to the Supreme Court. First, the Colorado District Court found that the president is not an officer of the U.S., nor does the 14th Amendment mention the office of the presidency. But District Court concluded January 6 was an insurrection and that Trump participated in it. The Colorado Supreme Court overturned that decision in part and affirmed in part on a vote of 4-3, so close, stating that the president is specifically mentioned and that the president is an officer of the U.S. They affirmed the portion of the District Court's decision that January 6 was an insurrection, that Trump participated in it. So Trump sent a petition of certiorari to the U.S. Supreme Court, which just means that a higher court reviews the opinion of a lower court. At some point, we'll get away from Latin in the U.S. Just got to get all the Ivy Leagues out of the halls of justice so regular lawyers like yours truly can use regular words. The Supreme Court analyzed the history of the 14th Amendment. Keep in mind, way back in 1866, we had just finished the Civil War and we're now in the time of Reconstruction. As part of being admitted back to the Union, states had to give up some of their autonomy. The court then analyzed the 14th Amendment, Section 5, which gives Congress the power, under court supervision, to determine and carry out all provisions of the 14th Amendment in good faith. Keep in mind, there was a significant volume of individuals who were elected to federal office post-Civil War that participated, or at minimum, aided in an insurrection. Think about the South. So what were the conclusions of the U.S. Supreme Court? First, SCOTUS, which just means Supreme Court of the United States, determined that states could determine whether or not an individual could hold office under the 14th Amendment and by state statute. However, SCOTUS maintained that Congress exclusively holds the power to determine one's fit for federal office and quoted Term Limits Inc. versus Thornton in 1995 in making the determination. SCOTUS furthered their discussion by providing a visual by words of how the states do not have the power of mandamus, which is just a command to a lower court. My God, let's get rid of these damn Latin words. Against federal officials, or the power of habeas corpus. There's some Latin again, which just means show me the body. For individuals in federal custody, quoting McClung v. Stillman, 1821, and Tarbell's case, 1872, so old jurisprudence. SCOTUS further determined that the Elections and Electors Clause under Articles 1 and 2 also did not provide any state power for a state to determine someone was not fit for federal office. In fact, going back to the 14th Amendment, meaning that they discussed it and then they jump back to the 14th Amendment. Section 3, it would require a 2/3 vote from Congress to remove anyone from a federal ballot or office. In the footnotes, SCOTUS describes how shortly after the enactment of the 14th Amendment that Congress removed an elected official by the name of Nelson Tift. In addition, as jurisprudence often dictates, there are no former cases where this issue has ever been brought to SCOTUS for them to rely favorably for the state of Colorado. Essentially, if you go back to how a law becomes a law, it is Congress that has that power. SCOTUS can only enforce or overturn. SCOTUS cannot make laws. Another issue for the state of Colorado is the Enforcement Act of 1870. This law, in essence, required that federal attorneys in federal court bring civil actions to remove anyone holding non-legislative positions. This case originated in the state of Colorado, meaning that it went through state courts. It did not go through any federal court. The Confiscation Act of 1862, which precedes the 14th Amendment, also holds provisions for the federal crime of rebellion or insurrection and the inability to hold federal office. Again, I am going to shamelessly plug my January post that is linked in the comments where I analyze the law of insurrection and rebellion. SCOTUS made it clear, in order for an individual to be eligible to hold federal office, that it would require a conviction of insurrection. SCOTUS then discussed how a federal election holds a national interest, and they fear a patchwork that would be created if states were indeed able to remove candidates for ballots. So, for example, let's say you're a big Biden fan, but the state of Texas removed Biden from the ballot. Now you have all of those electorates that Biden can't get because states have that power. So they were essentially stating, no, we can't have states doing that. What everyone needs to understand is that all 9 members of SCOTUS determined that it was the correct decision to allow a state the power to remove a federal candidate for ballot. And I'm going to drink my Stella Artois and let you marinate that, because it was all 9. The concurrences, as has happened in many other cases in history, will likely be how history views this case. For example, Youngstown Sheet and Tube Company v. Sawyer, where the concurring opinion regarding what constituted executive power is now the law of the land. So if you went to law school, you know exactly what I'm talking about. The concurrence written by Justice Barrett agreed that states do not hold the power to remove a federal candidate from a ballot. However, she limited her concurrence because of the temperature that this charge election has essentially created. Her goal was to turn down that temperature. You either really love Trump, you really hate Trump, and then there's a bunch of us that are just like, we don't really care. The concurrence written by Justices Sotomayor and Jackson took a different path. They agreed that the patchwork federal election cycles would be against the nation's federalism principles if states had the power to remove a federal candidate from a ballot. That was enough for them to concur. Again, you don't want Biden or Trump being removed from the state of Texas or California or New York or whoever has large electorates, because essentially they'll never hit that 270 threshold. And if you don't know what I mean by that, may want to do some research on how many electorates it takes to become a president. So Justices Sotomayor and Jackson disagreed with the idea that only Congress can be the determining factor in the federal government for an individual being disqualified from office for insurrection. Justices Sotomayor and Jackson opined that Congress, by a vote of 2/3 majority, could remove a disability, meaning that if an individual, in this case as we're discussing, someone is accused or convicted of insurrection, were elected, then Congress, by a 2/3 vote, could determine whether that individual could continue to hold office. So they disagreed about what the 2/3 meant. Justices Sotomayor and Jackson essentially accused the majority of flipping the meaning of the Section 5 of the 14th Amendment. They also stated that nothing in the 14th Amendment required legislation. Justices Sotomayor and Jackson then eviscerates the majority by showing, just using plain logic, that the majority opinion insulates those in the future who are actually convicted of insurrection from being challenged to hold office in the future without a congressional vote. They also stated that the majority foreclosed an individual being disqualified from federal statute as well. So what does that mean? So that means we have the federal statutes regarding insurrection. Again, shameless plug, listen to my January post. And you have what the majority is talking about with it takes a 2/3 vote from Congress to essentially remove somebody from a ballot. They're stating that there's some logic that's missing here. This is a strong concurrence drafted by Justices Sotomayor and Jackson that will ultimately be viewed in the future should federal cases start going through the courts. In fact, I believe, in my world's okayest opinion, that their points will be the mechanism for either Congress to address this in the future or for SCOTUS themselves to resolve the holes created by the majority opinion. So, long story short, all 9 justices stated that a state does not have that power. That is what you need to understand. And then Justices Sotomayor and Jackson created a potential mechanism should a case like this ever come back to the Supreme Court to be viewed. So, like what I had to say, please be sure to follow me on whatever social media you saw this posted on. I cannot thank you enough for listening to what my world's okayest opinions are. Lastly, it costs $0 to be kind. It's the best money you'll ever spend. Until next time, beautiful people, be well. Peace!